has instructions, they have applications. So
I listen
those
to,
are the things that
yes.
I was avoiding to go into. And in here, as you like to say, habeas corpus by its nature. Yes? It's a very serious matter.
Yes, my lord, I agree with you.
It's a very serious matter
Yes.
that we cannot just look at and say no this or that. So the issue you are saying, I hear, but I will make myself, I don't want to say much.
I get the concerns of the court.
Let me read it again.
Yes, most obliged.
So you are,
My lord.
respond the petitioner?
Yes, my lord. For the petitioners, we are asking for just 15 minutes.
I'm very grateful for this.
So I'm giving them officially that I'll allow them in the situation.
Okay, my lord. But
So
firstly,
you oppose the application?
yes, my lord, we oppose the application. We have since filed and we rely on our replying affidavit sworn on the 16th, which has also been served on all the respondents.
Give me a minute.
Okay, my lord.
It's allowed, were your plans allowed in?
Yes,
Yes,
I
my lord.
really want to thank you. Thank you, my lord.
So, Mr. Young, proceed.
Yes, my lord. So I will address the last limb of our submission. One,
So organize your thoughts. This is not the kind of case where you split. You argue a point to the other and argue a point.
can we do two here, my lord?
What? I don't allow. 10 minutes.
Yes, my
By the
lord.
time you change positions,
No, my lord.
3 minutes have gone.
Yes, I will only take 3.
Put your thoughts together.
Yes.
Is a small matter.
Okay. Okay, my lord.
I'm giving you a minute there.
Oh, it's- Thank you, my lord. Short. That's fine. It's fine. Okay. It's fine. Okay, yeah, it's fine. That's fine, my lord. And I'll go. Sure, my lord. I will start on the first ground on the powers of this court to grant interim reliefs. It has been claimed that they are final in nature and that they occasioned miscarriage of justice. My lord, Article 23 of the Constitution grants this court the authority to issue an appropriate relief including interim reliefs. Yes, my lord. This court and also the apex court, that's the Supreme Court of Kenya, has interpreted that provision in Gatirau Peter Munya versus Dixon Mwenda of 2014, application number 5 of 2014 at paragraph 86, that interim reliefs are issued so as to enforce the Constitution and they are public in nature.
So which paragraph?
86. They are public in nature and are issued to enforce the Constitution and also for the protection of human rights. My lord, Rule 23 of the ex parte interim reliefs. 23. So the question is, what was the appropriate relief as at that time when the application and petition were filed? In that application and petition, the first petitioner alleges that the second to fourth petitioners are missing, and therefore ask for a habeas corpus order requiring them to be produced. And this court, it was kind enough and ordered that they be released and or in the alternative, the first respondent and the second respondent to appear in court. Therefore, the question of the right to a fair hearing cannot arise when you have been given a chance to appear and you fail to do so. On that point, my lord, I will rely on the decision of the ELC courts Andrew Ndaba Karanja, ELC E201 of 2022 at paragraph 66. It is Andrew Ndaba Karanja versus Ambassador Simon Nabukwesi. It is ELC number E201 of 2022.
So I'm saying it is unreported.
Yes, it's a recent decision.
Sure, my lord.
It was delivered yesterday.
Yes.
Yes, it was delivered yesterday.
You are not in that.
Yes, my lord. Now, on the second issue of public interest,
So which paragraph are you relying on?
at paragraph 66 of the decision. 66.
I hope you have freedom your colleagues.
Lord, I've been gifted with a tablet. I hope I can keep it.
That's not on my folder.
Yes, my lord. Then, at the other point, is that the public interest lies in lifting the orders as it was advanced by my senior, Mr. Kuria. We submit that that is not the case. Public interest lies in the strict observance of the Constitution. Article 238 lays down the principles of national security, which includes the respect of the Constitution and its values. When the right to life is threatened, Article 238 of the Constitution lays down the principles of national security, and this includes the respect of the Constitution and the values and principles. The respect of the Constitution, the rule of law, and the national values and principles. My lord.
Let me put respect to Article 10.
Sure, my lord. Sure, my lord. Yes.
Is that the way to put it?
Yes, my lord.
Repeating those things.
Yes. Yes, we can summarize it as the
Principles in Article
10. Yes. So, my lord, when the right to life is threatened, public interest lies in holding the security agencies accountable. One of such ways is giving them a chance to come and explain. Your order issued on the 8th does that, my lord. My Lord, now I'll go to the second issue on service, where much time has been spent on it. Firstly, my Lord, when you retire, you will note that all those authorities submitted to you are distinguishable.
So what is your point?
On
See, you should tell me the point, then you go now to explain.
Oh, okay, my
What
Lord.
is the point regarding service?
Regarding service, and second, respondents were properly served. From our replying affidavit, my Lord.
You can now go to those divisions.
Okay, my Lord. Okay.
So that you don't lose your
Sort of this. So the point that I was advancing is that the authorities submitted before you, they are distinguishable and inapplicable in this scenario. We say so, my Lord, because the authorities submitted, they don't touch on service on public officers or public officials or public offices. They are all personal disputes in civil and commercial. The case here before you is about public officers on whose contacts are publicly available. Yes, my Lord. And if you refer to our paragraph 10 of our replying affidavit, the CEO of the first petitioner, Florence Muturi, advised that the Law Society of Kenya has previously served these offices through the same emails. And she refers to the ongoing case has previously served court documents to the same respondents using the same email addresses. That is paragraph 10, subparagraph B. And she lists down the case number. Paragraph 10, she refers to the last known addresses of these public officers. And she avers that when the first petitioner filed High Court petition number E714 of 2024,
714.
yes, of 2024, it served the court documents using the same email addresses. And when the society appeared here before your brother Justice Mamuye, no objection was raised. And my Lord, the very same counsel goes on record and was in court that day. Senior Counsel Nyamodi. He was representing the very same parties. And then time was also spent on the contents of an affidavit of service. My Lord, when you retire, you will consider Rule 14.2 Form B of the Mutunga Rules. It provides for the contents of an affidavit of service. Form B issued under Rule 14, Sub-Rule 2.
So Mutunga Rules 14C.
Yes. Form B.
Sub-Rule 14.2.
Yes, my Lord.
Form B.
Form B.
Capital B.
Yes, my Lord.
Yes.
Yeah. A person serving is only required to address how it was served with no extra requirements of extracts. We submit, my Lord, that at Mutunga rules regulate petitions, and the civil rules can only apply, if at all, where there is a gap. We submit that there is no such gap. And lastly, here, my Lord,
I was just about to ask.
yes, my Lord,
Lastly,
there is no evidence before you that those email addresses do not belong to those public offices. Article 245 of the Constitution establishes the office of the IG of Police and in the National Police Service, and he is the commander. He is the one responsible.
that is the first response.
Respondent. Yes, my Lord. So, if that office is served, my Lord, then such a high-ranking officer can be accessed through that email. How else can Kenya ranking officer in order to effect service? I will end, my Lord, by referring to a decision that I am the youngest here on the bar. That the prayer to set aside is a discretionary relief. It must be demonstrated that there is hardship.
There are two positions.
Yes, my Lord.
Position.
Shavas Mbogo and another of 1967 East Africa. At page 116, my Lord.
Page 16.
116.
I was trying to see whether you remember.
Yes, my Lord. So, yeah. So the prayer to set aside is a discretionary relief, and it can only be granted where there is extreme hardship or a miscarriage of justice, my Lord. but they cannot be delivered or granted where they are being sought to obstruct the delivery of justice. Kenyans, my lord, and the families of the second to fourth petitioners want to know where their siblings are. That is the main goal of this application and petition. Setting aside those orders will not lead to that result, my lord. It will actually allow the bleeding of the Constitution. And as Senior Thande Kuria submitted, the jurisdiction to do injustice, we submit that the High Court of Kenya established under Article 165 does not have the jurisdiction to allow for the violation of the Constitution. That will be all from us, my lord. Thank you for the opportunity.
So what is your prayer?
My prayer, my lord, is that the application be dismissed, my lord, and the orders granted and that thing be confirmed.
I'll take it for you when I'm ready.
Mr. Nyamoge, I'll give you 3 minutes.
My lord, just to start quickly from the bottom, the decision of Shah versus Mbogo needs to be read together with the celebrated decision of Express Kenya versus Manju Patel. And in that decision by the Court of Appeal at the apex court of this country at the time,
Shah versus Mbogo.
read together with Express Kenya versus Manju Patel,
Read and understood.
read and understood together with Express Kenya.
With
Express Kenya versus Manju Patel,
Manu or Manju?
Manju, M-A-N-J-U,
Yes.
where it was held that where it is,
Citation.
I beg your pardon?
Give me citation.
I don't have the citation. I know the decision because I have relied on it before, but I didn't know I was going to use it because I had it 2 minutes ago.
So you're asking me to go and look for the citation?
I can supply it to your court clerk.
No, it's okay.
Where-
I'll get it.
Where it is held, my lord, that where it is established that service was not effected,
So that, where
it is established that service was not effected,
that service,
then the orders made by the court should be set aside ex debito justitia as a matter of right, as a debt to justice.
extracted, should be set aside.
Yes, ex debito justitia.
That's what Omondi said. Is it Omondi? The other one he said, Patrick.
Yes, that is what it says. My lord, the reference to Rule 14 of the Mutunga Rules
As a matter of right.
as a matter of right. My lord, the reference to Rule 14 by learned counsel for the petitioners is an afterthought. The evidence of service, and I will come,
So Rule 14
of the Mutunga Rules, is an afterthought. Because the evidence of service is the affidavit of service of Noel Oduori of the sworn on the 13th of this month. And in that affidavit of service, the law or the procedure directing service, according to the deponent, is Order 5, Rule 22, B and C.
Order 5,
Rule 22, B and C. And My Lord, there is the submission about, or the question that Learned Counsel posed to court. How else are Kenyans expected to reach certain high offices? Inferior quality of service that the petitioners have answered. It cannot be then Article 50, and it is for the petitioners then to ensure that the quality of service that they effect complies with Article 50. Everybody is entitled to the protection under Article 50, and I had stated in my submissions in chief that service is the gateway to Article 50. If this quality of service is allowed, what will happen next is that Learned Counsel will wait for the Inspector General's car to drive by, and he will fling pleadings at it and come to court and ask, but how else did you expect me to get to the Inspector General? My Lord, the responsibility to effect service is on the officer authorized by the court to effect service. That responsibility is not co-shared between the officer serving. If he is not an advocate, the advocate instructing that process server, or the client that is instructing the advocate in the matter. That responsibility is on the person who served process. I say so, my Lord, because there are explanations in the replying affidavit to the application that is before you this afternoon that seek to make clarifications about the affidavit of service. When your Lordship considered this matter on the 13th, what was before you was the affidavit of service. That is what evidences service, nothing else. My Lord, paragraphs 12, 14, 15, 16 of the replying affidavit are not contained in the affidavit of service. And because I have submitted that that responsibility is not co-shared, it is important for me to submit that those are not averments by the process server. Whoever is deponing to this affidavit merely instructed the process server to serve. They did not effect service.
Mr. Remote, you are on hand. You notice I'm looking for something. So you don't expect me to record you.
Most obliged, my Lord.
I'm looking for the affidavit of service.
I had asked earlier. My Lord, let me tell you where the affidavit of service is. My Lord, it is on page 29 of the notice of motion. My Lord, that is the proof of service. And really nothing else can be the proof of service. Any explanations rendered after the fact are after the fact attempts to improve the poor quality of service that is not in compliance with the law. My Lord, there was a very innovative submission by my learned colleague that the authorities that were cited are distinguishable because they do not relate to service on public officers or holders of constitutional offices. Again, I repeat what I have said, and I think I'm saying it now for the third time. Service is the gateway to Article 50. And for that innovative submission to hold water, then Learned Counsel was obliged to put before your Lordship that constitutional office or holders or high office holders are then not entitled to the protection under Article 50. Because what he is suggesting is an inferior quality of service. There was the submission that email contacts that were used to allegedly serve the first and second respondents are publicly available. It was important, and this is why I wish to cross-examine the deponent of the affidavit, that that averment should have been made in the affidavit in support or in the affidavit of service. The affidavit of service does not say where those email addresses for. There is an attempt to explain where they are from in the replying affidavit, and I have stated that service is an issue to be confirmed and evidenced by the process server. My Lord, circumstances do not give rise to jurisdiction. Jurisdiction of this court emanates only from the Constitution and the law. There have been submissions on behalf of by learned counsel for the petitioner to suggest that the circumstances of this matter then justify the abbreviation of certain hallowed provisions of our Constitution, such as the right to a fair hearing. My Lord, there was a decision there was reference to a decision. I believe it is Andrew Ndaba. I only have the paragraph here on the screen that my learned colleague has shared with me. And I wish to say that that decision is applicable for the following reason. And it has been misread by my learned colleague. The decision quotes the case of Union Insurance Company of Kenya versus Ramzan Abdul Danji, and it is Civil Appeal number 179 of 1998 and reported. And this is the passage from the Court of Appeal. The law is not that a party must be heard in every litigation. The law is that parties must be given a reasonable opportunity of being heard. And once the opportunity is given and it is not utilized, then the only point on which the party not utilizing the opportunity can be heard is why he did not utilize it. That is our point exactly. My clients were entitled to an opportunity to be heard prior to the direction that they come to court. The matter does not commence when they come to court. The matter commences when the notice of motion is filed.
Are you suggesting that there is a chance that we cannot, at the start of any matter, issue some order? Is that what you're saying?
My Lord, parties are heard before summons are issued.
Is that what you're suggesting? Because as far as I know, the law is, when you move, the court has discretion to issue orders that it considers appropriate. So is this your case that in all cases, you should not issue any orders until we hear the party?
My Lord,
Is that what you're saying? Because it seems like that's what you're supposed to suggest.
My Lord, there are two orders that you have issued. There are two orders that you have issued.
No, it's not about the orders I've issued. You said the argument was circumstances do not give rise to restriction.
My Lord, I want to answer your question by reference to this matter.
Go ahead, I'm listening.
In this matter, you have issued a habeas corpus,
Correct.
which has concluded the notice of motion.
Yes.
You have attend. I am saying that in respect of before the habeas corpus is issued, they are entitled to be heard. And before you direct that they attend, they are entitled to be heard either directly or by counsel.
The law says.
Article 50. The right to be heard. You know the
Habeas
case.
corpus, so that now, that's the argument. Let me record it. We submit that
Before orders are
or
issued
habeas corpus
and attendance,
and attendance
yes,
are issued, a party is elected
to be heard. My Lord, I say so for the following reason. And again, it is a matter that is glaring in this issue. And
remember, I gave you 5 and your back 5. You collect your thoughts. as you
let me collect my
find
thoughts.
out.
My Lord, that issue is important in this issue because
Everything is important.
it is a VAD.
You are responding.
Yes, it is a VAD in this matter. And it is a submission that was repeated by counsel that the allegation is that the petitioners are missing.
Correct?
Isn't it? There is no allegation that those petitioners are in the custody of the National Police Service. But your Lordship has then gone on and issued orders to the National Police Service to produce them. And the point I make is that it is important before your Lordship makes an order to produce, to hear the response of all the respondents. Because one of the possible responses to the people are not in police custody.
That is from the bank.
I'm saying that one of the possible responses.
No. We're not talking about the security council. Let's say this is a response.
No, my Lord. I'm not saying that that is the response.
So I will say it.
I'm not saying that that is the response. I'm saying that my clients are entitled to a response.
We are not recording possibilities.
Then perhaps, my Lord, what I then wish to kindly request your Lordship to respond.
Let me record what you are saying.
What I'm saying,
The possible. So one of the possible
responses upon being heard is that the petitioners are not in the custody of the National Police Service. But my Lord, having ordered that they be produced by the respondents,
it's not all the petitioners. Is corrected. Second to fourth.
I stand corrected, my Lord. No, the Law Society is a body corporate,
That's the submission.
and I am a member of the society.
Yes. The second to
Fourth,
petitioner.
because the fifth petitioner is no longer a party, are not in the custody. And my Lord, it is then prejudicial for the petitioners or for the respondents to proceed in a terrain where the substantive order to produce has been made. It is prejudicial for the respondents to proceed in produce has been made, the first and second respondents. And my Lord, because what the matter then becomes is not to produce them, but where are they? That is the effect that ex parte order. And my Lord, for those reasons, it is then imperative that the ex parte order made is set aside. The interpretation of Article 22 and 23 in Peter Munya, again, does not then give the court the ability to abbreviate the proceedings in the manner in which the petitioner has invited it to do. And I beseech you, my Lord, to allow the notice of motion that is before you this afternoon in terms of prayers.
those prayers
Be
or as prayed?
as prayed.
Thank you, gentlemen.
My Lord, there's a promise you had asked that after the tail end of everybody submitting, there are some issues that you wanted to clarify. I don't know whether that was done.
Which ones?
No, it's you who said that you are not holding brief for the petitioners. There is something that you wanted to ask at the tail end.
Which was that?
It was the point when you said that you were avoiding to ask the questions, but you already asked them, I believe. So
I was avoiding to get into the argument,
yes, yeah.
but Mr.
I just thought maybe like it escaped.
Your mind was somewhere.
Not
It is,
quite.
it is possible. Is there anything we have left? You remember he was asking for a ruling, and I told him that's my duty. You recollect?
I do.
So is there anything we have forgotten? Robert? Do we have on Wednesday? We have something on Thursday. What else on Thursday? Thursday. We had it in December. 23rd. At 11. So I'll consider your arguments. And because of the work we have, I will deliver my ruling on 23rd this month at 11 a.m. in open court. The orders issued on 8th and reaffirmed on 13th remain in force until then.